Okay, so let me introduce the panel very quickly here. All the way on the end, we have Janelle Callahan. She's an attorney with the Secretary of State, handling business in the Business Programs Division. And then we have Rosanna Viveros Amador. She is she's with the State Compensation Insurance Fund, and she's a regional marketing manager. On the far right, we have Chris Boudreau. Chris Boudreau is an operator in the industry. He's been involved with organizations from cultivation, distribution, retail, and so he's been through the trenches in the last 7 or 8 years. Chris, how long have you been in the cannabis industry?
Got in about 10 years ago.
Got it. Okay, so he's a veteran as well. All right, going through here, we've got Lila Fedler. She's with the State of California Taxpayers' Rights Advocates Office. And we have Eduardo Blanco. He is a special legal advisor to the Agricultural Labor Relations Board. And last but not least, we have Juan Calderon. He's district manager, State of California at OSHA. And so we'll begin with some real basic questions for the panel here. And we'll begin with Juan. So Juan, are cannabis businesses under the jurisdiction of the Division of Occupational Safety and Health?
The answer is yes, if you are an employer. The mission of OSHA is to ensure that every employer provides a safe and healthful workplace for its employees. Pursuant to the Federal OSHA Act of 1970, California since 1973 has been regulating workplace safety and health here in California. So if you are an employer and you have an employee or more, then you're going to be jurisdictional to the Division of Occupational Safety and Health. And our goal here is to provide you the information to assist you in being compliant with California's safety and health requirements.
Okay. And does the Division of Occupational Safety and Health have resources specifically for the cannabis industry?
Yes, we do right now. Firstly, we have a website. All you have to do is go to write in any browser CalOSHA and then write the term cannabis, and it'll take you to a page where we have extensive material available for you to link to and refer to it. We also have additional information where you can go to our CalOSHA consultation publications page that will provide you access to all of the written programs that you as an employer will need to have based on the type of operation you have.
And what are the most common issues or instances you're seeing specific to the cannabis industry?
Well, firstly, right now, because it's a new industry, what we find, this is again based upon real inspections done. Firstly, we've investigated several incidents where workers were injured in the manufacturing industry. Injuries that resulted in a serious injury, that means that the worker had to be hospitalized for 24 hours or more. So accident investigations has been one of the things that we are actively doing. The other one is the result of complaints, where a worker has complained to the division that the conditions in the workplace are unsafe or unhelpful. So it's currently right now the division has open inspections involving the cannabis industry. And like any other industry, CalOSHA basically arrives at a workplace based upon certain criteria. One, we're investigating a work-related injury that's been reported to us, or a fatality, or we get a complaint. Currently, right now, the cannabis industry is not an emphasis program industry. May that change? Only the powers above know. But currently, right now, the reason we show up at your workplace is either a complaint or an accident.
Chris, have you ever ran into OSHA? Okay. All right, continuing along the, yep. Where do you? Excellent. So we do have joining us now with the Employment Development Department, Roland Baroli and Carla Stell. And for the moment, we will continue with Eduardo. Eduardo, what is the Agricultural Labor Relations Act?
So the Agricultural Labor Relations Act is an act that protects farm workers and gives them certain rights and puts certain responsibilities on farmers. And how that applies to the cannabis industry is that cultivators and trimmers are considered agricultural employers. And it's sort of specific in the cannabis law that if you're getting your license from CDFA, which is the Department of Food and Agriculture, you're considered an agricultural employer, and you have to affirm on your annual licensing form that you're an agricultural employer as defined by the Agricultural Labor Relations Act, which means that you're then under our jurisdiction. Although they spelled it out that way, we would have taken the position that because we believe you are agricultural employers, you are under our act. So to us, it's kind of superfluous that it's there, but the legislature put it in the law, so there we go. Now, the rights that we protect are the rights of employees to come to you as employers and say to you, you're not providing us with things that are referred to as the conditions of work, meaning the things that some of the folks here are going to talk about. So the state of California, through the various laws, lays out what the conditions of work are. For instance, health and safety issues, overtime issues, payroll tax issues, if you're not making the proper deductions from their paycheck. So all these various things are the conditions of work. So if there's a problem with any of those things, your employees come to you, you cannot retaliate against them for doing so. In other words, you wouldn't be able to fire them, otherwise discipline them. Now, employees can ask for things above that. They could ask you for a wage increase, they could ask you for longer breaks, they could ask you for a higher overtime rate, and those things where they're going above what the state has said, you have the ability to say no if you want to do that, or negotiate with them if you want to do that. But you don't have, but again, you don't have the right to retaliate against them for doing that, asking for those things. We also protect workers if they're trying to organize, and if they're trying to be represented by a union. And in your industry, I'll be talking about in a minute about labor peace agreements, and that applies to that scenario. But again, you cannot retaliate against them because they're there trying to bring a union in, or they want to talk to union organizers, or they want to vote to be represented by a union in collective bargaining. And those are the protections there. And if the workers do want to be protected, be represented by a union, then they come to us after they file a petition, and we will then hold an election at the workplace. And if the majority of workers decide to be represented by that union, and there are no problems with that process, then our board will certify them as the representative for collective bargaining, and then you'll have to get into a collective bargaining process with whatever union they pick. The way our law is set up, if you guys, with certain processes that have to go through, but within a year after that point in time, if you haven't resolved and come up to an agreement between yourselves, then either party can come to us and ask for a mandatory mediation. And the law then says that, and typically it's a union that does so, and the law then says that an arbitrator will be appointed, and you guys will then present your information to the arbitrator, and the arbitrator will decide what the contract, what the terms of a contract will be, and then after that, essentially, there will be a collective bargaining agreement. So either you guys negotiate one, or the law provides that there will be one. And the reason for that is before that was put into place in agriculture, a lot of employers strung negotiations out, and the unions didn't feel that that was an appropriate process in terms of resolving, to get into a contract, so they went to the legislature, and the legislature changed that. So that is in a nutshell what we do.
And Eduardo, how frequently does that happen? Is that a common instance, and what segments does it happen?
So it hasn't really happened yet in cannabis with respect to workers being fired for retaliatory reasons. And, and our process is called unfair labor practice charges, so they would have to come to us and file an unfair labor practice charge, or the union would come on their behalf and file such a charge. We haven't seen that yet.
Okay. Chris, have you run into any unionizing?
Not union, but
Right. Is this the same department, or? Eduardo, are you only agricultural, or would you
Yeah,
have?
we're only agriculture. I should point out that for the rest of the industry, there is the National Labor Relations Act. And the reason agricultural employees are not protected by that is that when that act was created in the 30s, the Congress specifically excluded agriculture and agricultural employees. And up until now, California has been the only state to protect farm workers in this area. Within the last couple of weeks, New York, Governor Cuomo just signed a bill called the Farm Worker Protection Act, and it's going to be very similar to our law. And so, at the end of the day, right now, we're just going to have California and New York with laws protecting agricultural employers.
For this one, I might be able to have some meaningful input on. Is this? So ADP is the biggest by far paper company. I'm sure you guys work with ADP a fair amount. And ADP is not a fan of cannabis businesses, and so you kind of have to catch the right rep who's open to trying to change a little for their own sales purposes. So it can be a little bit of a challenge. I've had one business that ADP later came back and said, oh, we didn't realize you were focused on the cannabis space, and they declined to continue to work with us. But what we have typically done is, assuming everybody in your behalf that has a cannabis business would be using an accountant, strongly suggest you use an accountant, have them work with the ED, and then they can help remit your payments for you. So that's what we've always done, and never had any issues because they can handle the checking account payments.
Obviously, we cannot give any financial advice or any business advice on how to run your business, but we are open to both cash and online payments. It has been a slow start, but I think slowly businesses are starting to report.
Okay. Thank you, and let's continue now with Lila with the Franchise Tax Board. Lila, everybody or many entrepreneurs and small businesses tend to prefer an LLC. What do you recommend?
Well, in the state of California, you can do business in any form you want. You can be a sole proprietor, you can be an LLC, you can be a corporation. But you do need to start at your local level when it comes to cannabis. Any business, you've got to start with your local level. You're going to get your business license with your city and county, or cannabis license with your city and county. And they're going to dictate whether or not you can do whatever it is you want to do within the locality that you want. So I know a lot of people are going out there, they're going out and immediately forming an LLC. I've got this great idea. Well, when it comes to LLCs, you form an LLC within the 15th day of the 4th month after that LLC is formed, you owe the state of California $800. Whether you do business or not, whether you make a profit or not. When it comes to the cannabis industry, because this is an industry where we do expect there's going to be very high revenues coming in, it may not be very conducive to be doing it as an LLC. Because not only will you have an $800 annual tax as an LLC, California imposes a fee on LLCs. If you have $250,000 in sales during the year, not only will you have an $800 annual tax, you'll have a $900 fee. If you have $500,000 in sales, that fee jumps to $2,500. At $1 million, it's $6,000. At $5 million, it's $11,790. Whether you make a profit or not, because it's pretty much you're going to take your total income, you add back cost of goods sold, and if the answer's over $5 million, you owe not only $800, but the $11,790. Oh, and then that income is going to flow through to your members. And then they're going to pay their personal income tax rate. You know, at $5 million, that's another 13.3%. That's all an awful lot of taxes because you chose to do it as an LLC. Now, you can form an LLC if you want. You can make an election to be taxed as a corporation. If you make that election and it's effective upon formation, and it can be either as a C corporation or as an S corporation, you're going to move out of the personal income tax realm of taxation into the corporate tax realm of taxation. One thing about California, our laws currently do not conform to 280 Cap E, which is the federal provision that limits you to just your cost of goods sold. Corporations in the state of California or an LLC that is elected to be taxed as a corporation will get all of its ordinary and necessary business expense. You don't make that election and you form an LLC or you're just doing it as a sole proprietorship, you're going to not get all your ordinary necessary business expenses. Now there is an Assembly Bill 37 that is proposing to make decoupling us from the state federal rules on 280E, but that bill has to get passed by both houses and it has to get signed into law by the governor or allowed to come into law. If that, as that bill stands today, that won't even be effective until 2020, next year, right? If you make an election to be taxed as a corporation and it's effective upon formation when you do an LLC, you're not locked into that election. The federal law treats it as if an election wasn't made because you did it from formation date. But say this is year 2 and you make that election. Well, now you're locked in to that election for 60 months. You can't revert back if the California law has changed where we decoupled from 280E for 5 years. So it's always an important thing to consider. Have a good conversation about it with your tax planners and decide what you want. There are downsides to doing business as a corporation. EDD will tell you, under California law, corporate officers are considered employees. So if you are taxed as a corporation, all of your officers should be paid salary, reasonable compensation, so you will have payroll taxes. You don't have that when you're an LLC or a sole proprietorship. So there's a lot of things to consider. We can't, just like EDD said, we can't give you advice. What I tell people to do is run the numbers. If you've got a good business plan out there, you've got an idea as to what you think you're going to make or what your goal is to make, run the numbers. Do it as if you were a corporation. Take last year's tax returns, run the numbers. If you make the profit that you thought you were going to make and you're going to have the expenses that you thought you were going to have, run them through the 3 or 4 forms, sole proprietor, Schedule C, LLC, depends upon how many members you are as to what you are, if you're Schedule C or you're treated as a partnership, and run it through the S corporation, run it through the C corporation. See what makes the best sense for you, but do the whole thing. Don't just do the income tax portion. Also consider what's going to cost you for payroll taxes, because it will come into play.
One more comment for the LLCs. It's true that if they elect to be treated as a 1065 or a general partnership, they're not subject, but if they elect to be chosen as a corp, they're still subject to the same as corporation.
Okay, yeah. Chris, what do you want to know?
I had a quick question. You'd mentioned you could be, the state of California in general allows any type of operational type, under the formation structure. Do you know, does the BCC, the Bureau of Cannabis Control, do they allow sole proprietors? I didn't think they did. They do? Okay.
Yeah, I've been told by Cannabis. I haven't actually spoken with BCC on it, Bureau of Cannabis Control. But yeah, that, and it's really, it gets back to that, you know, checking your city and county, right? Because you do have to get the license with the city and county. And this is a mistake I've heard a few people have done. They went right out, they formed an LLC, and then they go to their local city and county and they're like, nope, sorry, we're not issuing licenses. Nope, we don't allow that. Nope, you're in the wrong locality. You've spent a lot of money. Sometimes they've paid for a service to go out and form these entities, which, you know, Janelle down here at the end, Secretary of State, that's where you form your entities with Secretary of State. You can do it online, and, you know, fairly easy. But you don't want to go down that path. The other thing about it is, I've heard from Canna-Business, right? You've got to get your plans, right? You've got an applicant, right? The concept here is applicant. Who's the applicant? A lot of people make the mistake and they put their name down. Well, if you're going to be doing business as an LLC or a corporation, or an LLC taxes a corporation, the applicant's not you. It's you as a managing member or a member of the LLC or the corporate officer. It's the corporation that should be applying. They will take you down the path. You can file for plans. I'm not sure what plans they require. I can't remember what they are called. But there's an application fee. In some cases, it's a $6,000 fee just to apply. Not to get a license, just to apply. Well, if you've applied under your name, and you actually need the plan to be under the name of the legal entity, they will make you pay another $6,000 application fee. Right? Because this is the analogy I like to give people when I say, when you think about forming a legal entity, whether it's a corporation or an LLC. It's like you just gave birth to an 18-year-old child. That child, what? They disagreed with me? That's the child that needs to be filing that application. You're going to sign as the acting member for that child. But it's a good analogy. You really take it to the full extent, right? An 18-year-old child can enter into contracts. They have the legal right to vote. They can go out and get loans. You're not responsible for making payment of those loans as their parent. But you may have to fund them. You may have to give them some money. You may have to give them some assets, right? You may give it to them or you may loan it to them. You may rent it to them. You can have that type of a contract with that separate legal entity. It's all a matter of how you want to structure it. We allow that. You can convert your entities. You can go from being a sole proprietorship to an LLC to a corporation or backwards. It's all a matter of just doing those proper steps. But there are consequences for doing it. By the way, corporations in the state of California get the $800 minimum tax waived the first year. They do not waive it for an LLC. The taxes for a corporation are due after the year is ended. Now, we do ask that you make estimated payments, and if you don't make an estimated payment, you'll get an estimate penalty, which is a fairly small penalty for $800. It's running about $30. An LLC that doesn't pay their $800 tax when it's due, and they pay it when they file their tax return, they've got an $80 penalty, plus interest. So it can be very costly. We do find a lot of people, they've jumped the gun, they've thought of it, and then they're like, but wait a minute, I gotta pay $800? I haven't even got licensed. Yeah, it doesn't matter.
Janelle, why don't you weigh in on this as well? Obviously, this is in your wheelhouse. The different types of business entities and what affects cannabis and you have on the street.
So at our office, we do business filings. So if you're going to form your business and then go seek a license under that business name, as I explained, you'd have to form your entity with the Secretary of State, most likely, depending on what entity structure you choose. So if you're going to be a corporation, an LLC, a limited partnership, or a limited liability partnership, you're required to form and file documents with the Secretary of State's office to do that. If you're a general partnership, your filing with our office is optional, and then if you're a sole proprietorship, then you do not need to file any documents with the Secretary of State's office. Once formed, you do have additional required filings as well as optional filings with our office. So For example, if you have two entities that you've created and you want to turn them into one entity, you would file merger documents with us. Or if you were going to change from like let's say you're doing a medical collective model previously and you want to change to a for-profit corporation type, you would do restated articles in order to alter your nonprofit corporation to a stock corporation. You could also do conversion, like for example, a stock corporation to an LLC, or vice versa. So these are the types of things that are filed with our office, and once you file them, you're required to give these documents on state applications for cannabis licenses. So in order to find those, we have our business search. I don't know if any of you have ever used that, but it's a really good tool. You can actually get free copies of documents that you filed with our office. You can go on there for LLCs and corporations. You just search by the business name, and it'll pull up your entity, and it'll tell you if you were in good standing with the Secretary of State's office. It also tells you if you're in good standing with the Franchise Tax Board, and then it'll have your last two statement of information filings, as well as any other documents that you filed with our office for all LLC filings and for most corporation filings dating back to the 1980s, and we're still updating those as we go. So that's just kind of the realm of things that you would file with us, and then like I said, the purpose of that is when you go to get a state license and you're doing it as a business, then you're going to have to supply your documents with that application as an attachment. And I believe, I know a change in ownership and maybe sparking license, but I believe you still even have to like update them when you make change filings with your business entity structure with our office. So those are all things to take into consideration before you actually go out and get a license.
Well, you touched on the statement of information. Do you want to touch a little bit more? Because that's the thing that happens with the Franchise Tax Board.
Yeah, so once you form either a corporation or a limited liability company, you're going to have required filings called statement of information. And you have to file that within 90 days of formation. And then depending on whether you're an LLC or a for-profit corporation or a non-profit corporation, you're required filing either annually or every 2 years after that. And then if your agent of service and process changes, you also have to file a new statement of information. And that document basically is just a one-page document that has information such as like your agent for service of process. If the entity gets sued, they know where to send those process documents to. And then as well as things like maybe your members or managers for the LLC or your CEO or something like that for the corporation. So that's all public information that is searchable and anyone can access through our business search. So keep that in mind if you're going to put, say, your home address on there or something like that. I know a lot of people make that mistake and then have issues when they realize that after the fact.
And that's being completely automated on our website now, right?
For required SIs for corporations, yes, and then for LLCs, yes. And we're in the process of doing a revision for corporate SIs that are permissive filing. So like if you just had information change in between your required filing period, that will eventually be online as well.
And what I was getting to is what happens is if the Secretary of State certifies that you failed to make the filing on time, you get penalized. It's either a $50 penalty for the not-for-profits and $250 for for-profit. But you'll get the bill from the State Franchise Tax Board. So a lot of people get confused by that because they get this $250 penalty bill from us. They don't know what it's about, and I have to refer them back to Secretary of State.
And that also affects your good standing with our office as well.
Yeah, I think if you continue to fail, you'll suspend them.
We suspend them.
So pay the $25 and fill out the statement info. Chris, what about in your various operating companies, LC, C Corp, S Corp? What's in your better experience?
Yeah, there's definitely a range, and it partially depends on your structure, or your preference. Some people prefer an S Corp or an LLC because of the pass-through opportunity and the income, and some of that gets a little specific. I definitely consult with an accountant or the accountant about that. Personally, I prefer, I can't run this mic. Personally, I prefer, thank you, I'm okay. Can everybody hear me?
It's getting recorded.
Okay.
Yep.
Oh, I'm sorry. My bad. Personally, I prefer C corporations, and the reason for that is the flexibility. You can convert a C corp to an LLC later if you feel right. If you feel like that's an election you want to take. But more importantly, and people get lost in this, you get all of the legal defense and the corporate veil protection of the C corporation. If you feel like, oh, you know what, I want the LLC because I want the pass-through income, and you're really struck by the pass-through income opportunity, you can just pass through all the net income. And there's ways to structure that out. I would want to be careful about how I word anything around this line down, but you can have your accountant help you, and there's ways that you can structure that compensation. But you can effectively manage some of these things in a very similar way that you've got a little bit more flexibility. And I personally, having talked to a lot of attorneys over the last 15 years, I used to be a corporate banker. I prefer the structure of, or I should say the legal structure, the legal protection offered by a corporation just a little bit more. And in this space, it's a little precarious, still a little bit wild, wild west. I think we've got a lot more regulatory structure now, but you have a lot of actors and characters that are maybe, whether they're in your company or companies that you're going to be working with, it's still not as stable or as maybe professional as I think everybody would hope to see. It's moving in a very quick direction in a positive way, but we're not quite there yet.
I would also say that, the Jobs Tax Act has gone a long way to make the schedule, the C corporation more advantageous, because federal has actually reduced the tax rate that the C corps pay, bringing it down below what an individual high rate would be.
That is a great point. That's actually something I'm looking at right now with one of my companies is the current administration has actually put a cap of 20% tax rate on a C corporation at the federal level.
Right? It's 25, but I might be wrong.
Well,
It's
I don't know federal law.
The 20 is what you can deduct from
Qualified business income expense.
you guys are the pros, huh? I let the accountants handle that, but the bottom line is the individual tax rate goes up to 37%. So there's a meaningful difference in meaningful opportunity. You need to be mindful though, because now that's captured in the corporation. So if you want to use that for personal use, now you got to pay it yourself, and not have those assets trapped in the corporation. So.
And you have no benefit on California, so it's not quite that spread. Let's go to Rosanna with the State Compensation Insurance Fund. Rosanna, what are the requirements in California for employers to secure work compensation coverage and provide safety?
First of all, it's the law. If you are an employer in the state of California, you must, and you have one part-time employee or hire a day laborer or anything, you are required to secure a workers' comp policy in the state of California. Very important to know, can be cash payment. Okay, often employers think, well, I'm 1099ing them, I'm not paying payroll taxes, I'm not doing that, therefore they're not an employee. Technically under workers' comp law, they are an employee. So if that employee goes out and they're working at your, cannabis retail store and they get injured, even though you're 1099ing them, they are eligible for workers' comp benefits. And if you have not secured a policy, there are penalties that can be levied against you as an employer. Okay, so even though it's cash, even though it could be a 1099 format, or it could be someone that you just hire for a day to get set up, and next week you hire somebody else. There's that interchange of labor where you are asking them to perform duties in the form of being the employer-employee. You need a workers' comp benefit. Okay. This also protects you as an employer. You go out, you hire somebody, and believe it or not, your family members will come back and file a claim against you. Often people think, well, it's my brother. I'm going to have him come and work. Okay, well, let's say your brother maybe doesn't have health coverage, and he sustains an injury. It has happened, so it's best my best advice for you is to safeguard yourself against that. So you
Leave the
don't
family
have,
at home.
if you have a workers' comp policy, all the benefits associated with a injury that arises or occurs out of employment is covered. So that carrier covers medical benefits, okay, so all their medical bills, temporary disability. Let's say the injury is, somewhat severe and that employee cannot come back to work for a week or so. You pay the benefits for that. Permanent disability. Let's say it's a significant injury. A person is, in the farming or agriculture or tree trimming sustains a really bad back injury. Cannot go back to that type of work. We will cover benefits for that. So this covers you all. It also can minimize or take away the right for that individual to come back and sue you on a personal level. Okay, so it is the law, it is a requirement. Temporarily disability currently is 2/3% of the average weekly wage or whatever your employee is making. And the maximum amount of time that an employee can be eligible for this benefit is 104 weeks. Permanent disability, that's where, look, I really hurt my back, the doctor says I hurt my back, and because of that, I can't lift, or I can't, extend my arms higher, or whatever. There's an actual medical restriction put against me. That can be paid, up as long as the claim is open. There's also death benefits, because yes, unfortunately, employees do die on the job. So there is a death benefit that is paid out on that. So the other thing that's very important with workers' comp is that as the employer, you have to provide a safe working environment. Okay? In accordance with OSHA law and all that, you have to provide a safe working environment. So your workers' comp carrier can advise you on that. Being from state fund, we have extensive material on our website and helping them what's the requirement to have an injury and illness prevention plan on board, what's the requirement if you're doing anything with regards to air particles or respiratory. PPE needs to be used, okay? It's your responsibility as an employer not to just put someone out there to do a job. It's your responsibility to provide a safe environment, make sure they have been trained on how to do the job, and that if there is some kind of hazard out there in the work environment, that you're training them on how to properly work in that environment. Okay? So that's really what workers' comp is. The main point is just because you're paying in cash and there's no evidence, they can still come back, file a claim. And if you do have, there are policies out there that where the employer says, well, it's just me, I'm operating, but I use subcontractors or I use temp for agencies, PEOs, whatever, labor contractors, farm labor contractors, and they're not my employees, they're in other entities. Make sure you have a copy of their workers' comp certificate, because they will come back and file a claim.
Chris, what are your experiences?
In the past, so I got into cannabis when the financial collapse happened in 2008. And so the majority of my time in cannabis has been a little bit more stressed market, where people are a little bit more concerned about reporting that they work for cannabis companies. So fortunately, I haven't had any issues with this, because in the past, anybody that maybe would have been more inclined in today's world to go wasn't as excited about going to the state and saying, hey, I've been working for this cannabis company. It's a little more clandestine. So there was some upside to the marketplace we got. But I do have 3 scenarios I was wondering about if they would qualify. If you're a sole proprietor, getting things started, so it's just you, a sole proprietor, and it's just you, would you need workman's comp in that situation?
No.
If you're starting, you formed a corporation, and it's just you, so now you're I guess you could be an employee of the company depending on what you're doing. If you are an employee, would you need to have the corporation?
There's a couple of factors that go into play here. If I own a corporation 100%, I own ABC Cannabis Company, and I have no employees. Okay, I'm the only one. I'm not covered. There's no employees. There's no need for a workers' comp. But we all know, sooner or later, I can't do the job by myself. So what often happens is they will not procure a insurance policy. Then let's say 6 months in, they have to hire someone. At any time at that point in time, you need to start securing.
Or if they, it sounds like if they own a partner, and now you've got 2 or 3 people that own the corporation, and 1 or 2 of those people are employees. In that situation,
You have to own stock.
Oh, so if you own stock at any
You
level.
own stock and you have a title of president, within a corporation, president, secretary, vice president, you can be excluded from the policy. You do not need to have it. But if you're, there's a lot, we can talk here forever about ownership and stuff within it. But sole proprietor, no employees, there's no need. It also depends on who you're interacting with. Because sometimes, I know within the construction industry, people won't work with you unless you have a workers' comp policy. Because if you come on their job site, if you come and work for them and they get injured, they can file against whoever has the policy.
What about volunteers, such as maybe interns or board members?
It depends on what the board of directors determines. You can have, you cannot cover volunteers. Let's say you're having an event, and you're going to bring people out to an event, and you don't want any coverage. You can have that. Or you can have colored volunteers where it's going to be maybe like an extensive amount of time where they're going to be working for you. Then what you do with the carriers, you agree upon payroll on that. And then you pay off of that.
So let's say it was an intern or something a little more prolonged, it's not necessary.
If you're not paying them, they're not bad employees.
I want to first, actually.
Actually, I
With
thought,
the intern, you do.
yeah, I think that,
Just something related, not to workers' comp, but like for as far as state disability insurance, if you're a sole prop, obviously you're not covered for disability insurance, but you can actually do connected coverage, which is DIC. If you're self-employed, you meet the income requirement, you can be covered in case an injury happened outside of work, or for maternity leave, or things like that, you are covered.
And sole proprietor can elect to be covered if they want to, but it's very expensive. So majority of the time that does not occur. But you can, same thing if I own 100% of the corporation, but I want to be covered, then there are minimum, maximum amounts that are put out yearly by the WCIRB that determine how much payroll, you have to pay workers' comp.
so I think this conversation highlights a couple of points that you guys should probably recognize, that these laws cross over each other. So things that apply over here also apply over there, maybe not necessarily the same way, but they do cross over. And so that means more things that you have to be aware of as you go forward in terms of how to deal with all these different things. It also raises the question about who's an employee and who's an independent contractor, and who's an employer. In the context of some of these laws, for instance, for us, if you hire a farm labor contractor, or if you hire some kind of temp agency, under our law, you, the grower, the cultivator, are still the employer, and we treat you that way. So any violations go to you rather than to the independent contractor, the farm labor contractor, or to some temp agency. And but under all of these other laws, the farm labor contractor or the temp agency actually may be the employer, and the law will look to them first. So you have those differences as well that you have to look at. The other thing too, by the way, if any of you are in the temp agency business, if you want to provide labor to a cultivator, you have to get you have to be registered with the Department of Labor Standards Enforcement as a licensed farm labor contractor. You cannot provide labor in agriculture without that license. You'll be violating the law. The person that's hiring you will be violating the law, and there are penalties and fines for doing that kind of stuff. So please make sure if you're hiring in ag, in the cultivation part of the industry, that whoever you hire has to have a farm labor contractor's license.
Just some comments on the term independent contractor. Okay. For the history that I've been with OSHA, which is 20 years, we've always defined an independent contractor based upon a California Supreme Court ruling that is called Baranda. It's a very old decision from California's Supreme Court that basically established 5 elements as to what a independent contractor was. Well, Baranda is history because as of last year, California Supreme Court just issued a brand new one dealing with the independent contractor. And that is a result of activities resulting from all of the issues involving our new industry called Uber and Lyft. Whether those people are independent contractors, whether they are workers. A class action lawsuit was brought before the state of California, and the California Supreme Court has issued a new decision. So you should be familiar with it. It's available on the internet. All the elements of the new definition of an independent contractor are free and available for you on the internet. What you have to do is use your favorite search engine, write down the recent decision on independent contractor, California. It'll bring it up for you.
So is that Dynamics?
Is
that final, or are there still a couple rounds to go?
The legislation has not gone through yet. So that's called the ABC test. It's going to be, it's going to supersede forever, but I don't think it's final yet.
For workers' comp purposes, we are still operating under the umbrella.
Correct.
We are not under the Dynamics. So we look at the independent contractor under the umbrella, hold on until the Dynamics is
Or it
passed.
is the same, yeah. It needs to be
Yeah.
passed by legislation.
Chris, have you run into any issues, I guess, classifying your employees and contractors and coming back and doing that?
No, I would say in the prior cannabis work environment, especially with deliveries, and I've had a couple of cannabis deliveries, there's a lot of people that wanted to classify employees as 1099 independent contractors, but we talked to a couple of attorneys about this very early on, and it was a kind of fruitless thing to do, because if there was ever any issues, it could be classified anyway, so we just did it properly from the beginning.
Anybody on?
Question regarding if the business is located in another state, like say the headquarters is filed as a business in Minnesota, and it has an independent contractor in California, what applies?
Okay, so for EDD purposes, it's 602, 603, which is localization. It needs to meet all 3 criteria. Like, if the independent contractor, which we found later, it's an independent contractor, if we find it to be employee, if he lives and performs services in California, it's subject to California laws.
Okay.
So you need to live and perform services.
And that's just obviously not just for cannabis, that's for
For
anything,
any
right?
business, yeah. That's why I said in the beginning that cannabis business are a business. And we do out-of-state audits. Like I've done out-of-state audits in Florida, Oregon, it's only with regard to payments issued to individuals in California for people living and performing services here.
Okay.
When it comes to corporations and LLCs, whether you form it in California or you form it in any other state, if you have an agent in this state that is engaged in a transaction on your behalf, that meets the definition of doing business in California. A lot of them want to go that they're a 1099. Well, it depends. We'll look at that. But they are what meets what we consider as the definition of an agent. And there is a case that's being litigated. It's Harley-Davidson, where they were arguing that they didn't have employees in California. They had an affiliate, and the affiliate employees would hand out the the forms to fill out for getting a loan. Although they weren't employees of the company, they were agents for them because they were acting on their behalf. They were ruled to be sufficient to be considered to be doing business in California, and that corporation is required to pay taxes in California.
Okay, for OSHA, if you're doing business in California, it makes no difference if your corporation is out of state, but if you're in California and you're doing work, you have to be compliant to our safety laws.
And as far as Secretary of State's office, if you're transacting business in the state, you have to qualify here by registering as an out-of-state corporation or LLC. And that's something that you would have to provide on your state license application as well, because you'd have to provide your certificate of good standing here.
And for workers' compensation, you would have to, oftentimes California benefits under workers' comp are higher than in other states. Okay, so if you have that person that resides here, you would have to have coverage for that person under California. We can provide coverage in California. Let's say the main operation is here, but you have someone working in Nevada. We can provide other states coverage for that. But the majority of the payroll and employees needs to be in California. You would need coverage there.
And for the ALMB, it doesn't matter. Many corporations are multi-state corporations in agriculture. So if you're operating in the state of California and you commit an unfair labor practice, or the employee decided to represent it by a union, then your division here is covered.
And I would point out the requirements to when you have to register with Secretary of State. You may not be required because the activity isn't so continuous and repetitive that you have to. But California, we look to the Revenue and Taxation Code, not the corporate code, as to who has to file and pay taxes. This really comes into play when you talk about LLCs that are tantamount to being a partnership. Under our laws, the activity of a partnership are deemed to be the activities of all of its partners. So you may have an out-of-state LLC, but you have one member that's a California member. Maybe they're not actively engaging such that they were required to register with Secretary of State. We're still going to deem them to be California doing business in here because they only have to pick up the phone one time during that year and have a conversation with regard to the business. That's an activity engaged in the state of California that's doing business here.
Let's change it to trademarks and other, cannabis IP. Janelle, what are the differences between what they can register nationally and California?
Yeah, so this is a big issue that I think a lot of cannabis businesses maybe aren't aware of or haven't thought of yet, because it's kind of something that you think about further down the road once you're already operating and have a brand that you want to protect. But cannabis-related trademarks and service marks aren't able to be registered federally. So registering in California would be a huge benefit in order to protect your brand associated with your goods or services for cannabis products. So in California, we permitted them to be filed starting when you could first get a state license, so January 2018. A couple things that you need to think about and do in order to register a cannabis-related trademark or service mark in California. The requirement under the law is that the mark is lawfully in use in commerce. And so for that to happen, that means a couple things. You can't register a mark for something that's prohibited under California law. For example, goods that are attractive to children, or maybe they have a cartoon on the outside of your packaging or something, then that's not going to be something that's permitted. You also have to make sure that you've gotten any local or state licenses and that you're complying with that aspect. And then as far as another thing that we would look at is if you're in compliance with any labeling or packaging requirements. So we're obviously not going to go into the fine details to make sure you hit every single thing that's for the licensing agencies. But if we see a specimen that you've provided as part of your registration and we see that there's no universal symbol on it, and things like that, like really obvious that you're not complying with it, then that's not going to be able to be registered. So you need to make sure that have your mark associated with something that's lawful and that you checked all those boxes before coming to us to file. You can register a trademark or service mark with our office online, and we have a new tool where you can actually search for trademarks and service marks that have been registered previously to see if there's anything that's similar to yours before you try registering. And that's something that's new on our website, so I would definitely take advantage of that. You can search by owner, you can search by class code, you can search by design code. So it's a really cool tool. I think if there's anything else I'm missing here.
That tool's on the sos.ca.gov.
Right, yeah. On our BizFile website, it's bizfile.sos.ca.gov. And then one thing that I wanted to note, just so you can kind of get an idea of how big this is, since we started registering cannabis-related trademarks and service marks, about 41% of the marks that we're seeing are cannabis-related. So that's a pretty big number. So it's something that I would definitely think about and look into. It might be something that's good for your business. And if you guys have any questions, I'll be happy to dive into that again.
Chris, what have you seen in practice?
I would say maybe nothing that would surprise anybody or who's just applying. I would say I think there's probably more interest right now in people looking at genetics and names and strains, and if there's some way to capture that and own that. But as far as retailers or that are trying to build chains and want to protect the name of their brand or brands themselves that are building products, it's pretty much what you'd expect. Or it's just making sure that they get whatever they can in terms of protections.
Well, considering the proliferation of companies with Canada and copies and similar to that, there's some valuable idea there. Why don't we open it up to questions from the audience? Right now, we've got about 20 minutes left. Anybody?
I don't know if this is a relevant question, if anybody can answer that. I have a question pertaining to regulations regarding events. Is that for cannabis businesses that just focus on events?
I think that's the Bureau of Cannabis Control that issues those licenses.
Well, I just got some questions regarding like concessions. Like if there's an event that's not a cannabis event, I haven't found anything in the laws that like if you just have some sort of like a car show, right? You could have the ability to sell concessions as alcohol. You could have alcohol brands out there. Some foods. If you decided you don't want alcohol at the event, you want cannabis instead. I'm trying to find anything that guides how to do that, or if they still have to have the micro business license and the annual event license and the temporary event license. If you're just going to partner with somebody who's throwing a non-cannabis event, just have cannabis concessions.
Yeah, I haven't personally dealt with it directly, but I've worked with some groups that have.
Okay.
And I sit on the board of a couple trade associations, and we've had people look into it, so I can tell you by reference. I haven't spoken to the state directly, but I can tell you by reference that, from what I understand, you have to have a venue that will permit the cannabis, and then you also have to have the cannabis, the proper cannabis licensing at the state level to be able to facilitate it. So unfortunately, it's not as simple as going and getting a temporary alcohol license or a temporary food license. Like you have to get a venue. And so, for example, I don't believe, and I know a guy who's got he actually has a state venue or state event license. And he told me recently, maybe 2 months ago, that there's not one location in San Diego County that will allow events right now. So it's pretty tough. It's pretty tough to do. It's still very early. But on the flip side, I've heard recently about an exciting group that got a micro license in West Hollywood, and they got it actually at a venue. I think it was a music venue. And so they're actually looking at, they still have to do all the build up. They're going to be a year and a half out, but they actually might be hosting, and they're looking to host actual music events, concerts where you could not only consume, but you could sell. So I think it's on everybody's mind. consumption type venues, whether it's a restaurant, whether it's an event, are I think going to be the next big phase. They're just a little bit harder to get through because the industry quite hasn't. I would say the land use guys haven't quite matured at that point yet.
So if you want to have like a, sounds like if you want to have, like a cannabis event is easy to put on. Like I'm in Northern California, I can go to Cal Expo, it's really easy to do. There's all over the place. I don't tend to get to some stuff. But if you wanted to put an event together that catered to cannabis as the concession, that wasn't cannabis, like it's like a car show or something, you would have to just do it like you normally do a cannabis event, but then just do a car show, and by the way, these are concessions instead of beer.
Anywhere you're selling cannabis.
Okay, thank you.
Yeah?
So if I had a nursery and I wanted to have an event like a farmer's market, could I do that at the location where I have my nursery?
Same thing,
My own location.
you'd have to have the proper cannabis permit. Because it's not, what you're engaging in then is not nursery. These fine people all here will tell you all about this, but you're not engaging in nursery activity. Now you're engaging in sales of cannabis. You're facilitating the sales of cannabis at your location.
Even a swap meet with that, okay.
Yeah, same thing.
And maybe we should define cannabis a little bit. What are you trying to sell? Is it CBD, THC,
Well,
MC?
clones,
Clones?
yeah.
Okay. Are there any more questions, guys? Summer?
By the way, really quick, I think CBD clones, the trace elements of THC might fall under a different category, but I'm not sure. CBD.
Under 21%?
Yeah, or I think it's 0.3.
0.3.
Yeah, but CBD laws, for anybody that follows that, they're like the most minor and complicated space in the industry.
Question regarding the trademarks, and since there's not federal protection of the IP, then are we filing with the state, or the company's filing with California state, and then also filing with other states that have approved
Yeah, so you would be, with our department, it's the California state trademark, and then if you wanted to get with other states as well, then you would just do it through their state as well.
So you have to do all the states if you want like a comprehensive.
Essentially, yeah. I mean, you still have your common law protections, but if you want to try to get further protections, seek it with various states that you're engaging in.
The question is actually for Juan. I was wondering if you could give some recent examples of OSHA violations in the cannabis cultivation space.
Well, the most frequent violation being issued is where the employer has been inspected and he's been found that he doesn't have an effective injury and illness prevention program, which is a required written document since 1991 that every employer has to have a written injury and illness prevention program. The injury and illness prevention program regulation is the most cited one in California. That's the number one. For manufacturing, hazard communication. Okay? In other words, you have to have a written program for hazard communication that requires you to identify all the chemicals that you utilize in your processes. You have to have the safety data sheets for every one of those products. It can be electronically or it can be a paper document. You need to train your employees. You have to ensure that any secondary packaging or using a bottle for that chemical needs to be properly labeled. Those are the primary two standards we are citing. And in manufacturing also, eye washes is the other one if the chemicals are deemed to be corrosive. Those are the three main ones which are being issued. We do have certain, we had a recent case in Watsonville that resulted in serious citations issued to a manufacturer that dealt predominantly with failure to conduct inspections of the work processes. They had leakage in the system, resulted in elevated vapors in the workplace. Ignition, 2 workers were seriously injured, and again, the citations were predominantly the injury prevention program and inspections and failure to monitor for elevated levels of combustibles.
Thank you. As a follow-up to that, given that it's an emerging sort of segment in California, are there any preventive programs that would encourage these manufacturers to maybe develop health and safety programs through OSHA?
Well, it's number one, here today and tomorrow, I have the booth and I have a lot of literature available for you. I have model injury prevention programs. I have hazard communication available there. I have references of all the literature available for you that may apply to your industry available. We do have Cal-OSHA consultation. That is a free service to California employers. They do not issue citations. They provide professional consulting services to every employer in California. One of the things that I've been recommending at the conferences I've attended is that if you're a new employer and you need to develop your safety program, do please contact Cal-OSHA consultation for their services. Free.
And where do you find that on the website?
Well, just go to Cal-OSHA and select consultation. It'll give you the phone numbers for the 5 statewide offices of Cal-OSHA consultation.
What other free, sorry, I don't know, right, what other free services you guys have on your website? If you can, I don't know.
Oh, we have a lot of literature available there, written programs that you can download. Everything that we have on our website is free. It's public domain.
At the Franchise Tax Board's website, we have, which is ftb.ca.gov, we have a cannabis page. And when you get to that cannabis page, you don't see the answers to your questions. We have a link there that you're able to just submit and email your questions kind of anonymously. It goes to the subject matter expert to respond back and give you the answers to your questions. We also do have at the Franchise Tax Board a service called MyFTB. It's now, you see it says account. It allows you to register for you to have access to your own tax records. If you are a business representative of a corporation or an LLC, you can register as a business representative, and you would be able to see the accounts of that business. If you've got multiple business, you only create one business representative accounts, and then you add multiple businesses. Getting through the phone lines, the Franchise Tax Board in a state with over 40 million residents can sometimes be almost impossible. So therefore, we provide that to you. And if you've ever needed to get a copy of the tax return, requesting it from the department is going to cost you. If you've gotten your MyFTB account and it's been an electronically filed return, you can just print it right from the file.
Yeah, I second that. That's a great tool. Thank you for doing that.
And then with regards to workers' comp, State Fund has a very extensive website as well. We have a lot that deals with safety information, as well as how to get a policy, how to obtain a policy, what is involved in policy, what are the benefits that an injured worker is available to, and that's all public domain as well, whether you're insured with us or not.
The Secretary of State's office, we have our separate cannabis portal that has information about any cannabis-related questions about business filings or trademark filings with our office. It's cannabisfile.sos.ca.gov. If you just go to our main website, you'll be able to find a link to that. And we're constantly updating that. Like as I go to these events, if I'm getting specific questions on something, I'm going to be updating the FAQs on there. We have a brochure on there that goes with the different class codes that you can consider for trademark applications. We have a brochure on there that goes through different steps to forming a cannabis business if you're really at the start of it and confused on what agencies are involved and what steps you might need to take. So I would definitely recommend checking that out. There's a lot of good tools on there. And if there's something that's not on there, you can always give us a call.
EDD, that's in the Gulf, we have a lot of information regarding UI and UI, which is service that we provide. I'm from the tax branch, so what interests us is the e-service for business, which is the online version of where you can file, pay, manage your account. And also there are a lot of helpful tutorials that we have about employers how to classify their employees, and what's an independent contractor, what's an employee, and other issues.
We also have payroll tax seminars that we put on in different parts of San Diego. We have one coming up August 7th and September 11th. We have those flyers at our booth today if you're interested in looking those up.
Going back to your question, if you are a cultivator and you are doing outdoor cultivation, the primary concern that you have is called temperature. Since 2005, California has been enforcing the heat illness prevention standard. The trigger temperature is 80 degrees. You are required at 80 degrees to provide clean, potable drinking water to your employees. You need to have 2 quarts of water per worker per hour for them to drink. It needs to be free. You cannot charge for the water. You need to provide shade for the workers. If you give them a break, the shade canopies have to support the number of workers that you are giving a break to, or during the lunch periods. You are also required to give them rest periods. So rest, shade, and water, you are required at 80 degrees. If the temperatures are 95 degrees or greater, then you have to have a special written procedures to deal with the elevated temperatures. And again, the heat illness prevention standard is the second most cited standard in California year after year. Okay, and if you're doing indoor cultivation, in the near immediate future, we're going to have the indoor heat standard, and that one, the trigger temperature is 82 degrees. And then at 87 degrees, you have to start doing extensive monitoring to determine the index heat factors in the workplace. And that standard is currently in the draft format at the standards board for you to look at it, but the standard will be implemented sometime by the 1st of next year.
Last question?
Yes, regarding the FDA.